President.
The Honourable Adam Searle.
Mr Deputy President, I rise to make a contribution in this debate, and I start by moving, 1, that the motion of Mr Pearson be amended as follows. A, in paragraph 1, omit all words after, quote, that this House condemns, unquote, and insert instead, quote, all those childcare, cultural, religious, sporting and other institutions, both public and private, including the Roman Catholic, Anglican, Uniting and other Christian churches in Australia, Jewish bodies, the Jehovah Witnesses, the Salvation Army, YMCA, Scouts Australia, private medical practices, public hospitals and state-funded homes for their abject failures to protect children from sexual abuse by members of the clergy and leadership who either, unquote. B, in paragraph 1A, omit sexually assaulted children whilst they were in their pastoral care, unquote, and insert instead, quote, sexually assaulted children whilst they were in their pastoral and other care, unquote. C, in paragraph 2, Roman I, omit, quote, that this House conveys its utter disgust and profound disappointment in Cardinal George Pell for his ongoing failure, unquote, and insert instead, quote, that this House conveys its utter disgust and profound disappointment in all those in leadership positions for their failure, unquote. And Roman numeral 2, omit, quote, who sought his help, unquote, and insert instead, quote, who sought help, unquote. 2, that the amendment of Mr Shoebridge be amended by omitting all words after, quote, that this House calls on, unquote, and inserting instead, quote, the Australian and New South Wales governments to take appropriate action against any person or body that has assisted any organisation to avoid producing to the Royal Commission materials on both the extent of child abuse, comma, and the systemic handling of child sexual abuse claims, unquote. With that, I rise to make a contribution on my amendment and also on the substantive matter. And I'd like to start by acknowledging the genuine motivation of the Honourable Mark Pearson, who brought the motion before the House. But in conversations with other members, it's quite clear that there is no chance of the motion being passed in that form, with or without the addition moved by Mr David Shoebridge. I think it would be a terrible outcome in a debate on a matter as important as this subject is if this House were to reject a motion which called to account those who had engaged in, covered up or failed to address systemic child abuse, which I think would be the fate of the motion before the House. And I think that would be terrible because it would give a misleading impression to the wider New South Wales community that somehow this House and its members were conniving in or covering up or in any way failing to address the seriousness of these matters. And nothing, Mr Deputy President, could be further from the truth. The most obvious comment that can be made about the motion in its current form is that while it is true as far as it goes, in many respects, it does not present the complete picture of what has unfolded before the Royal Commission. It is true that the Catholic Church and various parts of that institution have been rightly criticised, and the evidence has rightly shown that there has been gross mishandling of complaints of sexual assault of children for many years. And it is also true that a number of persons in authority in that institution fell well short in their pastoral and other duties to members of the church and their children. Although Cardinal Pell is singled out for special mention, and I make no comment about the rights and wrongs of that, only to observe that he is not the only person in a position of authority who has been the subject of criticism in this regard. And it would, I think, be misleading if the motion was to be left in that form. As I indicated, there are many other institutions of other churches, of other faiths, public and private, and also cultural, religious and sporting groups who have also, in evidence before the Royal Commissions, also been felt to have covered up in, connived in or failed to address properly allegations of child sexual abuse on an ongoing and systematic way. And so, given the very serious subject matter, and given the presently unbalanced nature of the resolution before the House and its likely failure in this place, I have crafted some amendments to give a more complete and I think more balanced picture of what has been the evidence before the Royal Commission, and in so doing attempting to create a platform that all honourable members and parties in this place can join in and support, so that this House can send a clear and uncompromising message to the wider community that we condemn the inaction of churches and other bodies in our society for their failures in this regard, that we express our utter disgust and profound disappointment in all of those persons in positions of authority and leadership, in all of those institutions where they, putting it kindly, fell short of their obligations, and putting it perhaps more accurately, absolutely neglected their duties and, in some cases, covered up these allegations. It is important that, given that this chamber was the first parliament in Australia, that we do not drop the ball on this important issue and that we send a clear and unambiguous and strong message about how we feel about those failures. And I would urge all honourable members to join with my party and myself to round out the conversation commenced by the resolution, to make it more balanced, to give a fuller picture of the full range of failures of different institutions in our society, religious, cultural, public and private, and send a very clear message that we will not tolerate it. And with those few comments, Mr Deputy President, I urge the amendments on the House.
Mr Deputy President.
The Leader of the Government.
Mr Deputy President, I rise to speak for the Government on the motion moved by the Honourable Mr Pearson about child sex abuse. I acknowledge the contribution that the Leader of the Opposition has just made, and I'll return to some of his comments later. I wish to also acknowledge the contribution of Reverend the Honourable Fred Nile in this debate when he spoke on the 23rd of February 2017. Reverend Nile noted the importance about using language that is suitable for the House. The abuse, assault and sexual exploitation of children is abhorrent. Preventing abuse and protecting children and other vulnerable people in our community is a key priority for the Government. Before I speak to the member's motion in detail, I wish to briefly inform the House on the initiatives taken by the Government to support survivors of child sex abuse and reforms to prevent institutional child sex abuse in the future. The Commonwealth Royal Commission into Institutional Responses to Child Sexual Abuse was established in January 2013 to investigate where institutions have failed to protect children or respond to allegations of child sexual abuse. The New South Wales Government strongly supports the Royal Commission. The Government is giving close consideration to the Royal Commission's findings, observations and recommendations that have been made to date. In November 2014, the New South Wales Government announced interim measures as a first step in responding to the issues raised by the Royal Commission. Interim measures included providing unlimited access to free counselling, providing improved access to care records and the construction of a memorial at the Parramatta Girls' Home. The New South Wales Government has also issued a Premier's Memorandum on the Model Litigant Policy for Civil Litigation and Guiding Principles for Civil Claims for Child Abuse, M 2016-03. It requires the state and its agencies to act as a model litigant in the conduct of litigation and guides government agencies on how to appropriately respond to civil claims for child sexual abuse. On 14th of September 2015, the Royal Commission released its final recommendations on redress and civil litigation reforms. A key recommendation in the report was that limitation periods should be removed for claims arising from the sexual abuse of a child, and the necessary amendments to legislation should have retrospective effect. In response to the recommendation, the New South Wales Government introduced the Limitation Amendment Child Abuse Act 2016. The Act amends the Limitation Act 1969 to remove limitation period defences from actions for damages that relate to the death or personal injury of a person resulting from child abuse, including sexual abuse, serious physical abuse, and any other abuse connected with sexual abuse or serious physical abuse. The Royal Commission also recommended the establishment of a single national redress scheme for survivors of institutional child sexual abuse. On 4th of November 2016, the Commonwealth Government announced that it will establish a national redress scheme and invited states, territories and non-government institutions to join in the scheme. The Government has announced that it intends for the scheme to commence operation next year. The federal government has announced that it intends for the scheme to commence operation next year. The New South Wales government continues to encourage the federal government to work with all jurisdictions to implement a truly national scheme so that survivors of abuse can obtain the redress they need. The New South Wales government expects that religious and community organisations that are subject to allegations of sexual abuse will, in time, opt into a national redress scheme. All responsible government and non-government organisations must acknowledge the serious harm caused by institutional child abuse and provide redress to survivors in an appropriate manner. Section 316(1) of the Crimes Act 1900 criminalises without reasonable excuse a person failing to bring information which might be of material assistance in securing the apprehension, prosecution or conviction of a person who has committed a serious indictable offence to the attention of the police force or other authority. Section 316 was part of a suite of public justice offences that were inserted into the Crimes Act in 1990 by the then Liberal National Government. I understand that Section 316 replaced the common law misdemeanours of misprision of felony and compounding a felony. The offence under Section 316 applies to people that conceal or cover up historical child sexual abuse. I note that the motion calls for the federal and New South Wales governments to take appropriate action against any person who's assisted any organisation to avoid production to the Royal Commission. I wish to inform the House that the Royal Commissions Act 1902, Commonwealth, contains a number of criminal offences relating to failing to produce evidence before a Royal Commission. They include intentionally giving in evidence before a commission that the person knows to be false or misleading, destroying documents or things the person knows or is reckless as to whether the document or thing may be required in evidence before a commission, and intentionally preventing a person from attending as a witness or from producing anything in evidence before a Royal Commission. I call on any person with evidence of acts that might constitute these offences to provide the evidence to the appropriate authorities. The failure of institutions to report child sex abuse is unacceptable and should be condemned in the strongest terms. That is why the government is supporting the motion today. But I return, as I did earlier, to the comments of the Leader of the Opposition, and many of them we agree with. He has moved an amendment which I think has gone some way to providing us with a motion which the whole House can support, but we would like it to go a little bit further. The key change that will be in the amendment that I move is to condemn any and all institutions which failed to protect children from sexual abuse. The government feels that this is the most appropriate characterisation of the House's condemnation. This is also consistent with the evidence and research considered by the Royal Commission that a wide range of institutions failed to protect children. So, Mr Deputy President, I move 1. That the amendments of Mr Searle be amended as follows. A. In paragraph 1, omit all those childcare, cultural, religious, sporting and other institutions, both public and private, including the Roman Catholic, Anglican, Uniting and other Christian churches in Australia, Jewish bodies, Jehovah's Witnesses, the Salvation Army, YMCA, Scouts Australia, private medical practices, public hospitals and state-funded homes for their abject failure, and insert instead all institutions which failed. 2. Omit members of the clergy and insert instead their members. B, in paragraph 1A, omit pastoral and other. Mr Deputy President, I believe that with this amendment that I moved, this is a motion that the whole House can agree on and will pass and will be an appropriate statement of condemnation about the appalling things that has been done to children. I would commend my amendment, the Leader of the Opposition's amendment as amended, I hope, by my amendment, and the motion, therefore, once amended, to the House.
The Honourable Paul Green.
Thank you, Mr Deputy President. I'd like to just respond to the member's motion, and I do appreciate the different array of thoughts around the table and amendments. Mr President, I was at an event this morning, a report released by Anti-Slavery Australia, and talking about the sex exploitation of children. And one of the questions to one of the detectives there was, you know, what sort of profile's been done and what sort of research has been done in terms of identifying those that abuse children. And of course, it's quite disturbing. But can I make it very clear in this chamber that it doesn't matter what race, what religion, what creed, what sex these people are. There are people sexually abusing children, what career they have, whether they're employed or whether they're unemployed. There's a lot of people out there who are depraved and being predators on our children. And the depravity is getting worse, as we know from the previous presentation to the human trafficking inquiry by the former police commissioner, Andrew Scipione, who shared at that inquiry about the different and new technologies that people are using to exploit children. Some of those technologies, as I travelled through the US recently studying human trafficking, sadly some of those cases are just deplorable what's happening now in terms of not only the depravity but the decreasing age of those children being exploited. And no one can put their finger on a profile of a sexual predator. There's a lot of people from all sorts of places right across the world, to very rich and very poor, that are making, sadly, money out of that. So we did hear this morning that part of the commercial return on cyber sexting isn't always money. Sadly, one of the currencies at the moment is just the sheer fact that you trade an image for an image, and that's the currency. And so it's not all about being driven by money. But we can't. We've just got to be very clear in this chamber. It's not very helpful pointing the finger at one organisation or one institution. That is just so unfair. What we need to do in this chamber is respond in a way, as the Leader of the government just shared some things. And we know that we've got a Royal Commission into sexual abuse of the children. It's done an amazing work. And that will keep going. That will keep going for years to come. I just wanted to put on the record that there's a wonderful quote by Mahatma Gandhi, and I think I might be paraphrasing it a bit, Mr. Deputy President. And he says, "You throw a bit of dirt in the ocean, doesn't make the whole ocean dirty." And I've said this in the chamber before, I get really upset when we're starting to point the finger at a church or a church organisation. There are many institutions involved in this. There have been many people that have broken the law and ripped our children off of not only their sexuality, their identity and their future. And it's wrong for us to come into the chamber, I believe, and point fingers. I do encourage that I think the government's amendment to the bill is much more appropriate than trying to point the finger at someone or some institute, a particular institution, a particular creed or a particular race. Mr Deputy President, I'll also say this, because there has been a lot of church institutions that have been involved in this, and it's an absolute disgrace. And can I say for the record, it is by any means far, far removed from what Jesus had intended for our kids. And that's found in the scriptures time and time again of what Jesus thought of kids. And to see these people that have been given great trust, great responsibility, break that. And not only break that trust, but break families' trust, break the community's trust, is an absolute atrocious thing for us who proclaim the Christian faith, the Muslim faith, or the Jewish faith, or any other faith that's involved with this situation, where their leaders have let them down by pursuing those sexual abuses or child abuse. Mr Deputy Chair, I want to make another statement about that. I absolutely want to be unreserved in this comment, Mr Deputy Chair. I don't care who they are, what position they hold.
If I can just interrupt for a second. Just excuse me for one moment. It being half an hour after the conclusion of questions, proceedings will be interrupted to permit the Minister to move the adjournment motion if desired. Minister?
No. Mr President, I move... I need to do it now, David. I move, according to sessional order, that general business take precedence of government business for the remainder of this day.
The question is that according to that general business take precedence of government business for the remainder of the day. All those in favour, please say aye. Aye. Those in the contrary, no. I think the ayes have it. The ayes have it. Clerk will read the order of the day.
Private members' business, item number 4, standing in the name of Mr Pearson relating to the Roman Catholic Church, resumption of the interrupted debate. Mr Green speaking.
The Honourable Paul Green.
Thank you, Mr Deputy President. I just want to conclude, in light of timing and everyone's schedule, but make it very clear whether they're a movie star, a rock star, a radio star, unemployed, from the base of life to the highest office in life. No one, Mr Deputy President, no one is above the law. And we need to make sure that we do everything we can to act within the law to bring these people to account and to further what I've always said in this chamber and what I'll fight to until the day I'm finished in this chamber, which could be about 219, who knows. But we are committed, the Christian Democratic committed with all members of this House, to make New South Wales the safest place for a child to be raised and reared.
Yeah. Mr Deputy President.
The Honourable Adam Searle.
Mr Deputy President, I rise to make a brief contribution on the amendment moved by the Leader of the Government. I appreciate the Government members engaging constructively with the subject matter of the motion, rather than simply saying it's imperfect and we'll vote it down. They have constructively engaged with the subject matter and the amendments that I have proposed, and for that I thank them. It is regrettable, and I understand the appropriateness of making sure that we condemn all of those institutions who are at fault. I've got no issue with that. I would prefer that we did name them, because I think that was part of the original intention of at least part of the motion brought by the Honourable Mark Pearson. But I think the highest obligation on all members in this place is to make sure that there is a motion which we can all support, which rightly condemns the abuse, the failures to address it, the cover-ups, wherever they have occurred. And in that spirit, I can indicate that the opposition will not be opposing the government amendments.